Court is now open. You may be seated.
Thank you. Mr. McKenna?
Madam Chief Justice, may it please the Court, Your Honors. I represent the appellants and defendants in this case, Michael Jordan and David Barbuto, and we bring this petition for further appellate review to this Court because we submit that the Superior Court's expansive interpretation of what constituted a freeze-out resulted in excessive punishment to my clients. The equitable order was not designed to place the plaintiff in the same position she would have occupied but for the breaches, but instead impermissibly forced the two other stockholders of the company to buy her out. And this significantly improved the plaintiff's position from that which she enjoyed before she filed the lawsuit. We submit, Your Honors, that the Superior Court's exercise of its equitable powers should be reversed because that exercise contravenes the governing corporate documents as well as all existing Massachusetts legal precedent. Moreover, if left undisturbed, this legal precedent, which I submit is bigger than the facts of this case, will result in, it will become a powerful weapon in the hands of a disgruntled minority shareholder and will result in a plethora of new litigation.
Mr. McKenna, as you know, closely held corporations, they're very, you have overriding fiduciary obligations all the way around. To what extent can a closely held corporation essentially sort of rule out by its corporate documents remedies that might be appropriate in a given circumstance? In other words, a big piece of your argument is this contravened the corporate documents, correct, the buyout.
It is a part of the argument, but under Massachusetts corporate governance statutes, Your Honor, there is no ability of a minority shareholder to force the company essentially to liquidate when that minority shareholder no longer desires to be party to the corporation.
That's not when she no longer desires, when there's been a finding that there has been a breach of the fiduciary duty. That is to say, had there not been a breach of the fiduciary duty, then she couldn't, in other words, she couldn't move, for a partition or a sale in the court absence of breach of fiduciary duty. Here you have a breach of a fiduciary duty, and the court in those circumstances, has very broad equitable powers. Stated differently, if your clients hadn't breached their fiduciary duty to her, they wouldn't find themselves in this position.
I would submit that that is true in that had they not breached their fiduciary duty, we would not necessarily face this result. But on the date of the lawsuit, this lawsuit was not really about a breach of fiduciary duty. It was about a buy-sell agreement. And all of the facts show, and we do not contest the facts here, nor did we at the appellate court. The facts were on February 4th, 1998, all prior annual financial statements had been given to the plaintiff and to her husband.
She had to, this was after litigation, correct?
No, Your Honor.
This is before.
The evidence, right, and the exhibits that were introduced, a lot of the exhibits came from those that were produced by the plaintiff in the litigation. So the litigation certainly resulted in a plethora of additional voluminous documentation which fills the record. It gets down to monthly financial statements and tax returns and various other documents, hundreds and hundreds of pages for this two-employee corporation.
But if you had given all the information, which you do say you did in your brief, but then on page 27 you say, to remedy these breaches found by the Superior Court and put the plaintiff in the same position, et cetera, the Superior Court could have ordered the company to provide the requested financial information. Well, if you've given her all the financial information, how would that be a remedy?
Exactly. The Superior Court went to great lengths to say, you didn't give her quarterly financials, you didn't give her monthly financials. There's no statutory, even common law obligation to do it. But we're not contesting that part of the order. Interestingly enough, after making all those findings and having hundreds of pages before the judge in the original injunction does not then point to a specific document that she says this plaintiff needed. And let's look at from a practical point of view. What did the plaintiff need the information for? She, before the lawsuit, had been given every annual financial statement that was available, would have given her monthly, provided her with some additional information that she didn't have. That had never been a request. So I agree with Your Honor. The order where it says the defendants will provide, this is paragraph 4 of the injunction, will provide Mrs. Brodie and any other minority stockholder in the company, there's only 2 other stockholders, with annual financial statements for the company at least 72 hours prior to the annual meeting. I would agree with you. It was unnecessary. That's okay, though.
Are you saying that those had been provided at the time that that first injunction issued?
Well, the injunction was issued post-trial.
Right.
So, Justice Cordy, at the time of the lawsuit, all then prior prepared financial statements, annual financial statements, had been supplied. Once the litigation ensued, there were no further annual financial statements prepared, but every available financial document was given through discovery, as conceded by the plaintiff. The plaintiff would now argue, consistent with the Superior Court.
Is that actually is that reflected in the record here? Because I thought, in fact, some of these things still hadn't been provided as of the time of this injunction, and that's why the injunction issued, that this stuff had to be provided 72 hours before the meeting that was going to be held in July.
Well, I can't speak to why the court used those specific words, because there was no evidence presented that there was an annual financial statement that existed that had not been produced. What we know from the plaintiff's production and documents introduced in the record, up until the lawsuit, every available annual financial statement had been mailed.
Audited or unaudited?
Unaudited. This is a 2-employee company. It would be highly unusual.
Mr. McKenna, here it seems to me, as I understand your brief, you have not challenged her findings of breach of fiduciary relationship and the fact that she really doesn't have any way of ascertaining if it may be highly unusual to have audited financials. I'm not so sure it's highly unaudited. But it seemed to me if you go through the judge's quite extensive findings, what she's essentially saying is this minority shareholder has no way of knowing whether these are actually valid expenses, incurred compensation, brokerage fees, leasing of the cars, whatever it was. And the only way to remedy her in that situation is to let her, is to buy her out.
There was no claim made by the plaintiff that there was any fraud ever concocted upon her in any way. You
don't have to have fraud.
Well, the suggestion that you need an audited financial statement as opposed to one prepared by a CPA is for some...
It's a classic freeze-out, and she's saying, I don't know what's going on. All of these financial dealings, money is going to them. It may not be fraudulent, but I'm not getting my share, my appropriate share of the corporate assets.
And that, Your Honor, is exactly what Good versus Ryan talks to us about. The inherent risk of any minority shareholder, particularly a minority shareholder who does not contribute capital to the ongoing running of the company, does not employ with the company, does not consult with the company. In this case, this plaintiff inherited stock, and on the day of the lawsuit had received all annual financial statement. Now, we can quibble, as the Superior Court can seem to be, you did not give her every document. Well, the company did. The company, in response to broad and encompassing discovery requests, gave every specific document. And for what purpose? The plaintiff has no right to be bought out. The plaintiff has the right.
What does she have a right to?
She has a right as a minority shareholder, if the company dissolves, to get 1/3 of the net assets after creditors have been paid and after all assets are available.
Doesn't she also have a right to be treated equally with the other shareholders, i.e., get a salary or get a car or have the right to employment, whatever the other shareholder? Why not? Why doesn't she have that right?
Because that is not an inherent right of a stockholder. It's certainly, in a classic freeze-out case, and particularly one where a stockholder has made an investment in a company or in a family business, often you rely on the employment, and the cases speak to that is an essential part of your investment in the company or what your stock represents to you. This is not that case, and that's why the legal precedent of the appeals court, if left undisturbed, changes forever existing Massachusetts legal precedent. There are, in freeze-out cases, a variety, expansive remedies available to a court. In this case, as Judge Kantrowitz correctly discussed, we say, in his dissent, these powers are not unbridled. And it is up to the appellate courts to rein in the Superior Court judge if he or...
Am I correct in remembering that Justice Kantrowitz pointed, I mean, I don't know in large part, but part of his decision rests on the fact that the corporate documents didn't provide for, a proffer of shares for sale.
He pointed out a flaw in both the Superior Court's logic and in the appellate court's logic, which was that even assuming a breach of fiduciary duty, in this case, and one of the breaches that the Superior Court talked about was the corporation did not necessarily go through with the exercise of then valuing the shares and ultimately declining to purchase the shares. And all that was an option available to the company, which is no longer a party to the case.
Was there any question in this case about the shareholders not declaring a dividend that would include the minority shareholder?
No. There was a suggestion in Judge Kantrowitz's dissent that a minority shareholder, if he or she can prove that there should have been a dividend, and I remind this Court that all of the securities are owned by the company. The judge's ultimate decision and judgment, amended judgment, froze all of the securities.
So essentially, in a closely held corporation, if there is not a provision that would trigger a sale upon the occurrence of a certain event, the minority shareholder essentially is stuck holding his or her shares with basically no remedy. I mean, if they're a passive shareholder, they're stuck holding their shares unless they can, and they're not entitled to any income unless they can show that there should have been a distribution.
It's similar to children that inherit property, significantly valued property, but comes along with the life estate for one of the other family members. That's a significant asset.
Well, there's a difference. I mean, those are all kinds of different remedies in that situation, because in fact you can move for partition and sale and so on and so forth.
It wouldn't end the life estate.
No, it wouldn't end the life estate. Can I just look at the alternative remedies that Justice Kantrowitz suggested? In the circumstances of this case, he said he doesn't want to have the forced buyout. Director, officer, or employee, if she so desired. As I understand it, she doesn't so desire, and your clients don't so desire, correct? They might have fought that one. In other words, can you force an employee onto a closely held corporation? That goes to Justice Cowan's question.
Probably not. All the prior decisions speak to if you are an employee.
Correct. Okay, so those go out. Awarding her damages for having been deprived of a sought-after position in the past.
There was no evidence that she sought a position other than at the one meeting she wanted to become a board member, but that isn't necessarily an employee position.
That one doesn't seem to have much to it. Awarding her a share of the company's life insurance proceeds that it collected upon her husband's death.
That's where the case started.
And was there any agreement among the corporate papers that, or in the policy itself, that entitled her to receive a portion of those proceeds?
No, after discovery, that claim was abandoned.
Okay, so that one, has disappeared. Then, if dividends were wrongfully withheld or excessive salary was paid to the appellants, awarding Brodie her fair share of her money, isn't that in essence what the Superior Court has done here? In other words, to say, this woman has been damaged, she's entitled to monetary damages.
The danger of that I believe the court talked about in essence. That's actually a quote from the decision.
Correct.
But what the court said is, in essence, the parties don't desire, she said nothing about the distributions. In essence, the parties don't desire and can't work together. I'm going to sever the relationship, and it was placing the Superior Court's view of what might be a fair result. I remind the court, this plaintiff is still a one-third owner of this company.
No, I understand, but you haven't contested the factual findings that the judge made.
Under the standard that we would face, it was not a decision that we made to go and contest that the findings were clearly erroneous, given the expansive findings that were made in the case.
Did the judge make a finding that she had been deprived of certain dividends that she was due? Or
No.
No, I mean, there's no finding of that sort.
No, it's interesting when you look to see what the judge did to justify the result. The judge said, well, Mrs. Brodie might not have asked for more information, but you didn't give her enough or timely information, and that prevented her from selling. The plaintiff never made a claim that to any such fact the judge was mistaken. We argued it below, but our primary argument was the remedy was unjustified in light of the injunction that put the plaintiff in the position she was in the day she filed the lawsuit.
Well, I'm trying to understand the end game here. She first ordered that there be a sale, or excuse me, that your clients purchase the shares
At a minority discount.
At a minority discount, and then left it to the parties to work out a fair price. They came back, they couldn't work out a fair price. She then ordered that judgment be entered in the amount of $94,500, but didn't require her to transfer the shares back to the company?
Seemingly. The original order actually said it ordered the company to buy out. The company was no longer part of the case. The original memorandum of decision orders the company. And to Your Honor's point, the plaintiff came back and asked the judge to amend the findings to eliminate the minority discount. It was not that the parties could not work out a minority discount. The plaintiff would not accept a minority discount, and then the judge amended her decision and swapped the equitable order, or attempted to, and labeled it a breach of fiduciary duty and put the damages the same as she had originally ordered the company to buy out at the $94,500.
Would your clients have been happy if the judge had ordered the $94,000 buyout and the plaintiff surrender her shares?
I would say that despite it being contravening all existing legal precedent, that would not be a terrible result.
No, but would they accept it?
Would we today accept it? Or would we have then, Your Honor?
Well,
I'm not quibbling with you.
Would we accept it today? Would you accept it today?
Sure.
Would you have accepted it before?
Difficult question to answer, Your
All
Honor.
right, okay.
Thank you, Mr. McKenna.
Thank you.
Mr. Lightman?
May it please the Court. This Court took further appellate review of this case solely on the issue of remedy.
Correct.
We really aren't here, I believe, to argue about whether there was a breach of fiduciary duty. The Superior Court made extensive findings that there were. It was upheld by the appeals court and is not on review. So that issue, there really is no point in arguing about who gave what financial statement when, or whether dividends should have been issued. Those are breach issues.
But we're looking at the basis of the remedy.
That's correct.
I mean, if there's been no finding of any financial damage or harm,
The breach
then
of
how can you create an equitable remedy that says, but pay $94,500 anyway?
Well, the $94,500 is not plucked from the air.
The value of your client's stock.
It is the value that the Superior Court determined as the value of the stock.
But then ordered that be paid to you and your client not surrender the stock. How is that an equitable remedy that passes any form of muster?
I I believe, Your Honor, that upon payment of that money, they will have paid her for her shares. At that point, she's happy to send back the certificate, or for that matter, they could cancel the certificate. They have paid her the value of her equitable interest in the company, and she no longer has any interest. That is the point of...
Is a settlement in this
Didn't he
case?
just say that he'd accept that?
Well, he did. They certainly never have.
Go do it and we can forget the case.
And we would be happy to accept $94,000 plus prejudgment interest
Well,
up
that's a
till
separate
today.
issue. That's,
And-
the
and-
interest is a separate issue.
And I guess that's the remaining issue, because...
Yes, exactly. We hear on remedy, and that's why I went through quite carefully saying these remedies that Justice Kanslowitz pointed to as the alternative remedies simply don't make sense in the context of this closely held corporation where there has been a breach of fiduciary duty, correct?
I believe that's correct. I believe there's two very basic problems. One is the practical. The remedies Justice Kantrowitz suggested either don't work or would create even far greater changes in the law than we're asking. We're not asking for any change in the law at all. The second and fundamental issue here is that whether Justice Kantrowitz might have issued a different ruling were he in the Superior Court, there is no suggestion anywhere that the remedy ordered by the Superior Court was an abuse of discretion. And that's the standard. We're not here to decide could there have been a different remedy or might something else have perhaps worked. We're here to decide, did the Superior Court abuse its discretion in deciding that the real remedy here was to separate these people, essentially a corporate divorce, and give one side money and the other side...
I'm confused.
Mr. Workman, can I just ask you this question? Justice Kanslowitz points to the corporate documents. What are we supposed to do about that? That is to say, she received these from her husband, but her husband presumably was aware, there's no claim that he wasn't aware, that that this particular closely held corporation did foreclose the option of a buyout, correct?
Yes, the corporate documents in this case provided, in essence, a right of first offer by the company, where you could engage in an appraisal process, and then the company could offer to buy your shares at that price. We started down that road of selecting appraisers to value the stock, and then the company announced that it no longer wished to participate in that process, would not do so because of cost or some other issue, and simply stopped the process. The appeals court, including Justice Kantrowitz, found that that was one further piece of evidence of a breach of fiduciary duty. Again, not the issue for today, but they found that that was one further of many pieces of evidence of the freeze-out in this case. Your Honor is absolutely correct that these particular corporate documents do not provide the minority shareholder with any ability to force a buyout of her shares.
In the absence of a breach of a fiduciary
In the absence of breach of fiduciary duty. And that's the Good versus Ryan case, and that is the corporate documents in this case, and that is Chapter 156D. In the absence of a breach of fiduciary duty, the minority shareholder, with corporate documents like this, and owning less than 40%, under 156D, if you own 40%, you can force a dissolution, but she was less than 40%. There is no change of control type issue that would generate appraisal rights under 156D. And in this statute, this corporate documents, there was no ability to force a sale.
I'm confused because everybody's been talking as if the defendants had to pay the plaintiff and the plaintiff wouldn't tender her shares. But the judge's order says the defendants are hereby ordered to purchase the plaintiff's shares at a price to be agreed on, blah, blah, blah. And then, of course, I know it was there was amended findings, but that only went to interest and the value. So why is there this disagreement about whether she had to return the shares?
I don't think there's any disagreement. The judge very clearly...
I thought I heard the parties saying that she never offered the shares back, and that's the whole problem.
Mrs. Brodie has never taken the position that she's entitled to $94,000, $94,000
And to 42.
and the stock. That would be a windfall. That would be a rather peculiar result. She has always taken the position that, having been frozen out, the remedy she wants is to be done with these people, to not be in a situation where she remains a shareholder and has to sue them every year to fight about dividends. That doesn't make any sense for her. It doesn't make any sense for the company.
So,
surely, though, there's a difference between an initial order requiring this remedy and, indeed, if it starts to go through a series of they're back every year or every 6 months and contempt proceedings and whatnot, that eventually a judge could say they're simply not obeying orders, they've got to buy out her stock. But can you start there? Can you start there without first seeing whether the company will abide by a series of orders?
The answer is yes, and in particular in this case, what you had was a factual record showing that over many, many years, these two gentlemen, Mr. Jordan and Mr. Barbuto, had first, in effect, frozen out Walter Brodie so that he was receiving no information and nothing from the shares.
But at what point did they violate a court order?
I don't believe there was ever an argument that they violated a court order, nor do I believe
Once
that...
court orders are in play, that's a different situation. Normally, we give people the benefit of the doubt and expect them to obey court orders.
Not if there's been a finding of a breach of fiduciary duty.
There is no case that I know of from this court or any other court that has said that a violation of a court order is an element of breach of fiduciary duty.
But a remedy for a breach of fiduciary duty has to be tailored to the nature of the breach of the duty, and here it seems as though the judge went way overboard.
Not at all.
Do you have is there any prior case in which this type of remedy was ordered in this situation?
Yes. There are numerous. We would start, Your Honor, with
Donahue.
the Donahue case.
But in Donahue, the other shareholder had been bought out. The majority had been bought out. There was a sale already. So to make the minority in equal position, then they had to buy the minority. That didn't occur here. The facts aren't the
And
same.
in Donahue, wasn't the partner also the shareholder an active participant in the nature of the business?
That is correct.
And that's not true here.
The point, you can factually distinguish Donahue from this case.
Okay, is there any case like this where a minority shareholder, where there was no other repurchase by the corporation, where a court just ordered the corporation to buy the minority's shares?
There are several. There is one First Circuit case that I've cited where they awarded damages, this under Massachusetts law, where they awarded damages based on the value of the shares. There are 2 or 3 Superior Court cases, all cited in the papers, where other Superior Court judges have ordered a buyout at a particular price for a minority shareholder who had been frozen out.
Okay, but the only appellate authority is, you say, one circuit court case.
There are also, interestingly enough, virtually everyone, I know of only one state having looked at this issue, has decided that their trial courts do not have general equitable authority to force a sale in the condition of a freeze-out. And in fact, many of them cite to Donahue as the basic case establishing that equitable power.
But how many of these cases involve a passive shareholder who is not involved in the ongoing business of the corporation, and where the corporate documents do not provide any kind of a mechanism for a purchase of shares in these circumstances, where the original shareholder died and there's no insurance or anything else to cover the acquisition of the shares? Is there any other case that falls factually on all fours with this one?
Not that I'm aware of, where we have a passive shareholder. In most closely held corporation situations, you generally have active people. In this case, you have a passive one. But in this case, I don't think that may have, well, put it this way, I think that may have made our burden of proof of showing the freeze-out somewhat more difficult, because you did not have a situation where she was frozen out of employment or frozen out of office. But we met that, and we're not on review.
Why isn't the appropriate remedy in this case for breach of fiduciary duty a monetary award of the costs and attorney's fees that were incurred to acquire the information that was withheld?
Two reasons. First of all, this Court has previously held that attorney's fees are not available in breach of fiduciary duty cases. So that would, in fact, involve a reversal of this Court's decision where the current order is absolutely consistent with everything this Court has done.
But it is an element of the damages that were needed to obtain the information to which your client was entitled. It's not attorney's fees in the classic sense. It's attorney's fees as a measure of actual damages.
What I would suggest, Your Honor, is that it's confusing the issues of evidence and remedy. There were numerous pieces of evidence that were presented to the Superior Court to establish the freeze-out. One of those pieces of evidence was the refusal to provide information. One of them was not conducting annual meetings. One of them was the way the husband had been treated. There were numerous. Based on all of those pieces of evidence, the Superior Court found a breach of fiduciary duty. Having found that, the remedy then becomes not necessarily what about this particular piece of evidence or that piece of evidence. It becomes within the discretion of the Superior Court to provide an appropriate remedy that resolves this issue.
But by definition, an appropriate remedy is supposed to be one that puts the party in the position that she would have been in had the breaches of fiduciary duty not occurred. And by no stretch of the imagination does that equate to her being bought out. It clearly puts her in a position to which she would not have been entitled. What will put her back in the position she should have been in had these materials been disclosed? You order them disclosed. You order that they continue to be disclosed, that appropriate meetings be held, that she be given notice. You do all that. That's how you remedy it. That's how you put her back where she should have been.
Your Honor, the evidence for breach of fiduciary duty in this case was far greater than simply not providing information. That's a nice discrete point. But the evidence in this case was that these two gentlemen had run this business in a way that solely benefited them in terms of salary, rent, free work done, a whole host of arrangements.
Is there a claim that they got salaries that she believed she would be entitled to?
No, she was not an employee. The point was they were running the company in a way that solely benefited them, put all kinds of money and control in their pockets, and gave her absolutely nothing, and refused to give her information, and refused to deal with her husband.
But isn't that the problem that her husband got her into when he bought into a company like this where he was just a minority person, and he knew when he put in his money that he would never have the votes to outvote the other two?
That's not the standard for a closely held corporation. They have an obligation to deal with her with the utmost fiduciary duty.
No, I'm talking about the way they ran the company.
He was actually a founder of this company, and this is a perhaps somewhat classic situation where the company gets away from the founders. That happens in some closely held companies. But having found a breach of fiduciary duty, there is absolutely no reason why this Court should restrict the ability of the Superior Court to find an appropriate equitable remedy.
But again, if the breach is they've taken money out of the corporation for their own purposes, it was improper, excessive salaries, whatever, the thing that puts her back in the position that she should have been in if the breaches had not occurred is to require them to disgorge that, put that back into the company. It doesn't require a sale of the stock.
The best remedy here was separating these people, providing her with money, providing them with the stock where they now own 50% or will own 50% of the company each instead of 33. It's not a windfall to either one. They both get something. and they are no longer at each other's throats.
Well, that may have been Solomonic, but it was, I'm not so sure they were legally entitled. Your client was legally entitled to the remedy.
You're over your time, but he started by saying he'd accept that remedy. So perhaps you two want to talk about that and get back to us on whether you can settle this case. Think about it.
One
Thank you,
final
Mr.
question. I only see one judgment in this case, and it has nothing to do with your client surrendering shares. It has to do, or with the other parties buying shares. It says there's a judgment for $94,500 against these gentlemen individually. Are you saying you concede that that judgment really also, doesn't say so, incorporated the obligation on your client to surrender the shares upon payment?
Yes.
So why don't you talk about that and let us know.
Thank you, Mr. Whitaker.
Thank you very much.